Title 11, Section 94 of the Revised Corporation Code of the Philippines, which is the plan of distribution of assets, deals with the plan providing for the distribution of assets. Consistent with the provisions of this title, may be adopted by a non-stock corporation in the process of dissolution in the following manner. The first one is the Board of Trustees shall, by majority vote, adopt a resolution recommending a plan of distribution and directing the submission thereof to a vote at a regular or special meeting of members having voting rights. The Board of Trustees must approve a resolution recommending a plan of distribution by a majority vote. This plan outlines how the corporation's assets or properties will be distributed among its members or stakeholders. The approved plan must be submitted to a vote at a regular or special meeting of members having voting rights, and only members with voting rights can participate in the decision-making process regarding the plan of distribution. The second one is each member entitled to vote shall be given a written notice setting forth the proposed plan of distribution or a summary thereof and the date, time, and place of such meeting within the time and in the manner provided in this code for the giving of notice of meetings. The notice should provide a clear outline of the proposed plan of distribution, ensuring that members are well informed. The notice must specify the date, time, and place of the meeting where the plan will be discussed and voted upon. And the notice must be given within the time frame and in the manner specified in the Revised Corporation Code for ratifying members of meetings. And the third or last one is such plan of distribution shall be adopted upon approval of at least 2/3 of the members having voting rights present or represented by proxy at such meeting. The plan of distribution must be approved by at least 2/3 of the members having voting rights. The 2/3 majority is calculated based on the members present at the meeting or represented by proxy. This means that members who are not physically present can still participate in the decision-making process through proxy voting. Title 12, Section 95 of the Revised Corporation Code of the Philippines, which is the definition and applicability of title, deals with the closed corporation. Within the meaning of this code is one whose articles of incorporation provides that all the corporations issued stock of all classes, exclusive of treasury shares, shall be held of record by not more than a specified number of persons, not exceeding 20. This refers to the total amount of stock that has been issued by the corporation. This includes all type of stock issued by the corporation, such as common stock, preferred stock, etc. Treasury shares, which are shares that have been reacquired by the corporation, are excluded from this count. This refers to the stockholders whose name are recorded in the corporation's books as the owners of the shares. The total number of stockholders of record excluding treasury shares must not exceed 20. Next one is all the issued stock of all classes shall be subject to one or more specified restrictions on transfer permitted by this title. The primary purpose of these restrictions is to maintain control over the ownership structure of the corporation. Stockholders may have preemptive rights to purchase additional shares before they are offered to outsiders. The corporation of other stockholders may have a right of first refusal to purchase shares before they are sold to outsiders. Transfers of shares may be restricted to prevent ownership by non-stockholders or to limit the number of new stockholders. Other restrictions may be imposed, such as requiring stockholder approval for transfers or limiting the transfer of shares to certain individuals or groups. Next is the corporation shall not list in any stock exchange or make any public offering of its stocks of any class. Notwithstanding the foregoing, a corporation shall not be deemed a closed corporation when at least 2/3 of its voting stock or voting rights is owned or controlled by another corporation, which is not a closed corporation within the meaning of this code. The primary purpose of these restrictions is to maintain the private ownership structure of the corporation. A corporation will not be considered a closed corporation if at least 2/3 of its voting stock or voting rights is owned or controlled by another corporation. That is not a closed corporation. If a corporation meets the exception criteria, it will no longer be considered a closed corporation and will be subject to different rules and regulations. The exception criteria may lead to change in the ownership structure of the corporation, potentially affecting its control and decision-making processes. So any corporation may be incorporated as a closed corporation except mining or oil companies, stock exchanges, banks, insurance companies, public utilities, educational institutions, and corporations declared to be vested with public interest in accordance in the provisions of this code. The provisions of this title shall primarily govern closed corporations, provided that other titles in this code shall apply subsidiarily except as otherwise provided under this title. And also take note that non-compliance with any of the requirements shall not make the corporation a closed corporation. A corporation is not a closed corporation even if the shares being to only 20 or less stockholders, if not all the requisites are present.
This Section 96 provides special provisions for the articles of incorporation of closed corporations, which are companies with a limited number of shareholders, no public disclosure requirements, and restriction on share transfers. This section allows closed corporations to tailor their governance structure to suit their unique needs and relationships. Example: Company J, the owners can choose to run the business themselves without a board of directors. This means they don't need to hold meetings to elect directors, and they will be considered directors for legal purposes. They will also be personally liable for any problems or damages that directors would normally face. Additionally, they can choose to appoint the company's officers and employees directly. In essence, Section 96 provides closed corporations with significant flexibility in structuring their internal governance. It allows them to tailor their articles of incorporation to suit their specific needs and relationships, fostering a more direct and personalized approach to corporate governance. This Section 97 explains the validity of restrictions on transferring shares in a corporation. To be valid, these restrictions must be clearly stated in three important documents. One is the Articles of Incorporation, the company's fundamental rules. Two is the bylaws, additional rules that govern the company's operations. Three is the Certificate of Stock, the document proving ownership of the shares. If these restrictions aren't written in all three documents, they are not valid against buyers who act in good faith, meaning they weren't aware of the restrictions. Additionally, restrictions must be reasonable. They can't be too burdensome on the shareholder trying to transfer the shares. For example, the company of existing shareholders should have a right of first refusal to buy the shares. But this right must have reasonable terms and a reasonable time frame. Example: Company F might give its existing owners the first chance to buy shares before they are offered to the public. This right of first refusal would need to be written in the Articles of Incorporation, bylaws, and Certificate of Stock. It would also need to specify how long the owners have to exercise this right and what price they must pay. In short, restrictions on transferring shares must be clearly documented and reasonable to be valid and enforceable. Section 98 protects the unique structure and ownership control of closed corporations. It states that if shares are issued or transferred in violation of conditions set out in the Articles of Incorporation, the new shareholder is presumed to have known about the violation. This allows the corporation to refuse registering the transfer unless all existing shareholders consent or the articles are amended. The term transfer includes any change in ownership, not just sales. This section does not affect any legal recourse the transferee might have based on contractual warranties. In short, Section 98 safeguards the intended ownership and structure of closed corporations by creating a presumption of knowledge regarding restrictions and empowering the corporation to prevent unauthorized share transfer.
Good day everyone, I am Jamaica Constantino and today I'll be discussing sections 99, 100, and 101 of Title 12 Closed Corporations. These sections outline important rules and concepts that guide the agreements, operations, and unique features of closed corporations. I'll explain each section in a clear and straightforward way. So let's dive in. First, let's talk about Section 99, which addresses agreements between stockholders in a closed corporations. Pre-incorporation agreements. These are agreements made by the stockholders before the corporation is officially formed. Section 99 ensures that these agreements remain valid even after the corporation is incorporated, as long as the stockholder intended for the agreement to continue and the agreement don't conflict with the articles of incorporation. For example, if all stockholders agree before incorporation to distribute profit in a specific way, this agreement will remain binding after the corporation is formed. Next, we have voting agreements. Stockholders can create written agreements to decide how they will vote their shares. This could include agreeing to vote together in certain decisions and following a specific procedure for casting their votes. For example, two stockholders might agree to always vote in favor of expanding the company whenever the opportunity arises. The third point is about agreements that resemble a partnership. Some stockholder agreements might look like those between partners in a business. Section 99 clarifies that these agreements are not invalid just because they make stockholders act like partners. This ensures flexibility in how stockholders can collaborate. Now let's move on to the agreement about running the business. Stockholders in a closed corporation can make agreements about how the business is managed, even if it limits the power of the board of directors. However, stockholders who are part of such agreements take on additional responsibilities. Specifically, they become liable for the decisions they make, just like directors. For example, if stockholders agree to jointly manage a new project, they must bear the consequences of their management actions. Finally, stockholders actively managing the corporation have strict fiduciary duties to each other. This means they must act in good faith, be fair, and prioritize the corporation's interests. Additionally, they can be held personally liable for wrongful acts unless the corporation's adequate liability insurance. For instance, if a corporation is sued for negligence and there is no insurance, the managing stockholders will be personally liable for paying damages. To recap, Section 99 of Title 12 emphasizes flexibility in stockholders' agreements. It allows stockholders in a closed corporation to collaborate through pre-incorporation agreements, voting agreements, or even management agreements to override the board's usual authority, all while ensuring accountability and fairness. Now, let's move on to Section 100, which builds on this idea of flexibility by addressing how directors in a closed corporation can make decisions even without holding formal board meetings. Section 100 explains that even if a board meeting isn't properly held or notified, the decisions made during or without that meeting can still be valid if certain conditions are met. There are four key situations where this applies. First, written consent by all directors. If all directors give their written consent to the action, whether before or after it's taken, the decision is valid. For example, let's say the board approves a new law. If each director signs a written document agreeing to it, the action stands even without a formal meeting. Second, no objection from stockholders. If all stockholders know about the action and don't object in writing within a reasonable time, the decision is valid. For example, directors decide to open a new branch without a formal meeting. If the stockholders remain silent or supportive, the decision is upheld. Third, customary informal practices. If directors are used to making informal decisions and all stockholders approve of or don't object to the practice, then the action is valid. For example, in a closed corporation where directors routinely handle matters over casual discussions, those decisions are acceptable as long as everyone is on board. Lastly,
no objection from directors. If all directors are aware of the decision and none of them object in writing, the action is valid. For example, if a director hears about an action taken without proper notice but doesn't oppose it in writing, they are considered to have approved the decision.
Section 100 also addresses situations where a director didn't attend a meeting without proper notice. If the director learns about the decision later and doesn't file a written objection promptly, their absence is considered as approval of the action.
To summarize, Section 100 highlights the possibility in decision-making for directors of a closed corporation. It ensures that even without formal board meetings, action can remain valid if certain conditions are met. This reflects the practical, informal nature of closed corporation where trust and transparency are crucial. Now, let's turn to Section 101, which focuses on another aspect of closed corporation, maintaining control over who can become a stockholder. This is achieved through restrictions in the transfers of shares, which help preserve the close-knit structure of the corporation. First, let's define preemptive right. A preemptive right is a privilege given to stockholders to purchase new shares of stock before they are offered to others. This helps stockholders maintain their ownership percentage and influence in the corporation. Section 101 outlines how preemptive rights work in closed corporation. In closed corporation, preemptive rights automatically apply to all shares to be issued unless the articles of incorporation specifically exclude them. These rights cover not only newly issued shares but also reissued beneficiary shares. Shares the corporation had previously bought back and now selling again. Stockholders have the right to buy shares issued to exchange for money, cash payments, property, assets contributed to the corporation, personal services, labor or expertise provided to the corporation, and corporation debts, selling liabilities with stock instead of cash. This provision ensures stockholders have the chance to protect their ownership regardless of how the shares are being paid for. However, the right isn't absolute. The Articles of Incorporation can waive or limit preemptive rights. For instance, if a corporation wants to attract outside investors, the article might allow the new shares to be sold freely without giving existing stockholders the first option. Without preemptive rights, issuing new shares can reduce a stockholder's percentage of ownership and influence in the corporation. It ensures all stockholders have an equal opportunity to maintain their stake in the corporation. To sum up, Section 101 safeguards the ownership structure of closed corporation by granting stockholders the preemptive right to buy newly issued shares. It ensures fairness, preserves control, and prevents dilution of ownership.
Have you ever wondered how corporation can adapt to changing times? So let's talk about the Section 102 of the Revised Corporation Code of the Philippines, which is the rules on amending a corporation, the Articles of Incorporation. So the process begins with the Board of Directors or Trustees. A majority vote is needed to approve any proposed amendment to the Articles of Incorporation. Next, the amendment must be approved by at least two-thirds of the outstanding capital stock for stock corporation. For non-stock corporation, it's the two-thirds of the members. But what can be changed? The corporation may amend its name, the principal office address, the purpose of business objectives, the term of existence, or even the number of the directors or trustees. Once the amendment is approved, it must be filed with the Securities and Exchange Commission or SEC. The changes takes effect only after SEC approved or upon issuance of the certification. So remember, any amendment must comply with laws and public policies. It should also respect the rights of shareholder and members. So, Section 102 ensures that corporations remain flexible and adaptable while maintaining transparency and accountability to their stakeholders. Conflict in corporation is normal, but what happens when these conflicts reach a breaking point? So, that's where Section 103 of the Revised Corporation Code step in to address the corporation deadlocks. So, if a deadlock arises, any stockholder can file a written petition with the Securities and Exchange Commission or SEC. The SEC has the power to arbitrate the dispute and take action to resolve it. Under Section 103, the SEC can issue orders to break the deadlock, including first, canceling or altering provision in the Articles of Incorporation, bylaws, or stockholders' agreement. Second, overriding or enjoining corporate action or resolutions. Third, directing or prohibiting specific act by directors, officers, or stockholders. Fourth, requiring the purchase of shares from stockholder at fair value. Fifth, appointing a provisional director. Sixth, dissolving the corporation if necessary. A provisional director is an impartial person appointed by the SEC. They are neither a stockholder nor creditor and have the same rights and power as any elected director, including voting in board meetings. Their role is to help the corporation function until the deadlock is resolved. The SEC's ultimate goal is to restore corporate harmony and protect the interests of stockholders. In extreme cases, the SEC may dissolve the corporation to prevent further harm. Section 103 ensures corporations have a mechanism to overcome deadlocks, enabling them to move forward and thrive even in the face of the serious internal conflicts. In a closed corporation, what can stockholders do if conflict arises or if they want to leave? Under the Section 104 of the Revised Corporation Code, it offers solution for withdrawal and even corporate dissolution. Section 104 allow any stockholder of a closed corporation to compel the corporation to purchase their shares at fair value. This fair value cannot be less than the par or issued value as long as the corporation has enough assets to cover the debts and liabilities. This ensures stockholders can exit the corporation fairly while protecting the corporation's financial stability. In more serious situations, a stockholder can file a written petition with the Securities and Exchange Commission or SEC to compel the dissolution of the corporation. So, dissolution may be compelled if the acts by director, officers, or those in control are illegal, fraudulent, dishonest, oppressive, or unfairly prejudicial. And second, the corporation can compel if corporate assets are being misapplied or wasted. The SEC will evaluate the case and take appropriate action, whether it's to protect the stockholder rights or to dissolve the corporation to prevent further harm. So, Section 104 empowers stockholders with clear option to safeguard their investment or take action when corporate governance fails.
Good day, I am Jasmine Matugina and today I will discuss sections 105 to 107 under Title 13 of the Revised Corporation Code, which covers educational and religious corporations. Let's first discuss section 105. This section tells us that educational corporations are organizations created to provide facilities for teaching and learning. They can either be for profit, known as stock educational corporation, or non-profit known as non-stock educational corporation. Their operations are governed by special laws but they also follow the general provision outlined in the Revised Corporation Code. Then Section 106 Board of Trustees. The composition of the board in non-stock educational corporation shall not be less than 5 nor more than 15. Also, the number of trustees shall be in multiples of 5, which means it shall be 5, 10, or 15 only. On the other hand, the composition of stock educational corporation shall be the same as in ordinary stock corporation, which is not less than 5 nor more than 15. General rule: once the board is organized, they should classify or divide themselves so that the term of office of 1/5 of their number shall expire every year unless otherwise provided in the Articles of Incorporation or bylaws. If a trustee leaves before his term expired, the replacement serves only the remaining time of that term. On the other hand, trustees elected after the term's expiration serve for 5 years. Also, a majority of the trustees shall constitute a quorum for the transaction of business. Their powers and authorities shall be defined in the bylaws. Section 107, which encompasses the classes of religious corporation. Religious corporation can be established by one or more persons and are classified into two types. The first type is corporation sole, which is managed by a single person, such as bishop, priest, minister, or other religious leader. This individual acts as a trustee responsible for administering and managing the properties and affairs of the religious group. The second type is a corporation aggregate, which is formed by two or more persons working together for the same purposes as a corporation sole. These corporations are governed by the provision in this chapter and were applicable by the general rules for non-stock corporations.
So I am Maricel C. Ramirez and I will be discussing special corporations. Chapter 2, under religious corporations, we have the section 108, the corporation sole. So for the administering, a corporation sole may be formed by a bishop, a priest, or minister, where a corporation sole is a type of legal entity. Essentially, it is being managed by a single individual or usually a higher-ranking or senior religious leader, where he is given the authority to manage the assets or other matters of the corporation or the church. As I have said, it could be an archbishop, a bishop, minister, or any religious leader or senior religious leader that has a higher ranking in the church. So the person that is acting as or managing the sole corporation rather has all the responsibilities to decide on behalf of the corporation or group. So meaning it is more like management, since only one person is responsible to manage the assets, to make decisions and other legal matters. So the person is more likely to enter into a contract but does not involve any individuals. Well, it is just an example, diba? So for example, there is a large church or religious community like a Catholic diocese rather. So diocese, it is district where it has a lot of properties such as churches, schools, and land. So under Section 108, the Catholic Church could create a corporation sole, which means that the head of the diocese, typically the bishop, is legally recognized as the official entity responsible for managing all the property and financial matters of the diocese or the district. So in this case, the bishop will hold title of the corporation sole, and this gives him the authority to handle all legal matters like buying or selling property, entering into contracts, or managing the finances. While the bishop is the corporation sole, he is still acting on behalf of the religious community, and he's just the only one legal recognized to manage everything, actually making the process simpler and more efficient for the church. So this way, if the diocese needs to make a decision about the sale of a property, for example, the bishop can do so, like he can sell it without needing a group of people to make that decision on behalf of the church. It makes things faster and more organized in the corporation. So Section 109, under the same chapter and title, it is the Articles of Incorporation. So Articles of Incorporation, a church may form a sole corporation that will be managed by a bishop. That is under Section 108. But for Section 109, for it to be considered as sole corporation, first it should, or the leader should prove that they have the authority to act as one or to manage such corporation. Second is the individual who manages the church must not create rules that oppose its legal structure or oppose the tradition rules in religious corporation. Third, the leader must state that he has the legal power to manage the church's assets or other matters. And fourth, he or the managing individual must explain the process to be followed whenever, for example, the position becomes vacant, either due to resignation of the leader or death of the legal or other legal reasons on how it can be filled. So it must still follow the rules under religious tradition. And lastly, the location of the church or the corporation rather must be specified by the managing individual or bishop and should be within the country or within the Philippines. The articles of incorporation may include any other provision not contrary to law for the regulation of the affairs of the corporation. And next we have the Section 110 or 110, submission of the articles of incorporation. So it is just a continuation of the previous section, which is the articles of incorporation. So the leader or the individual who manages must include an affidavit when submitting the articles of incorporations, since it serves as a proof that the documents being submitted or being filed are true or original, together with the proof of the individual's position in the church, and should be verified by a notary public. And after filing, once it is verified, it can now act as a sole corporation managed by a religious leader and can now be responsible for all the assets and matters of the corporation as he is held in trust to manage on behalf of the religious group, not for its or his personal benefits.
As we continue our exploration for the revised Corporation Code, we will now cover Section 111 to 113. These sections are essential in understanding the framework governing corporation souls, which are typically established for religious purposes. In Section 111, we will look into the powers of corporation soul, outlining the authority granted to these entities in carrying out their functions. In Section 112, we will discuss the registration requirements and formalities for establishing a corporation soul, highlighting the necessary steps for legal recognition. Lastly, we will dive into Section 113, which provides the process for the dissolution of a corporation soul, detailing how such entities can be voluntarily dissolved and their affairs properly wound up. Section 111, Acquisition and Alienation of Property. So a corporation soul is allowed to purchase and hold real estate and personal property and must be used for church, charitable, benevolent, or educational purposes only. The corporation can receive gifts for these purposes. So for example, if a religious group receives a donation of land for building a school, the corporation soul may hold this land for educational purposes only and nothing more. And in terms of selling or mortgaging the real property of the sole corporation, it must first obtain permission from the regional trial court where the property is